Well, thank you for having me today. I'm glad to be here and talk about this. I think it's a very important topic that a lot of people sometimes will put off talking about or don't necessarily enjoy talking about. But it's an area where everyone has something to learn and something to gain by exercising critical thought and doing some planning. So specifically today I was asked to talk about, from a legal standpoint, what happens when you get a diagnosis from a doctor, or what happens when you receive news from a doctor that's going to have severe impacts on your life. And eventually that's going to happen to all of us in one form or another, whether it's us directly or a loved one of ours. But the situation happens, the doctor gives the news, and obviously you've got a lot to do and think about from a medical standpoint. And so I'm not here today to talk about from the medical standpoint. That is by no means my area of expertise. But what I do spend a lot of time helping people with is, from the legal side, what needs to happen. What's next? We get the bad news from a doctor, or they say something that has us alarmed. From a legal standpoint, what needs to happen next? And I tell individuals, you've got to have, when for life in general, and even more importantly, when you get that bad news, you've got to have a plan in place. You've got to think ahead and assess, because we all, every day, we exercise our ability to make decisions. And as we get older, or as circumstances in our life changes, it impacts our ability to make decisions. And then ultimately we die. And upon our death, decisions have to be made. And so we want to control how and when those decisions are made. So the first thing that needs to happen when you get a negative, or you get a poor diagnosis from a doctor, is you have to assess the timeline you're dealing with from a legal standpoint. People come to our office for, they always call it estate planning. Everybody thinks they're coming to our office for estate planning, because that's what a lot of attorneys say. I'm an estate planning attorney. But a lot of the planning we do is more life planning. It's helping people plan for what's going on in their life. And so you get this diagnosis from a doctor, and first thing you need is some good life planning to help with decision making. And you've got to assess the timeline that you have in front of you. And so when people come into our office, sometimes it's because they just got news that they're going to have heart surgery the following Monday. And now they're panicked because they're having a major heart surgery and they've not done any advanced planning. Sometimes it's mom or dad is in the hospital and it's becoming more apparent that they can't go home and live by themselves. And so they need to know about what happens if they go to a facility or a rehab facility. How does all that work and impact finances, things of that nature. Sometimes people come to us because they received a diagnosis, maybe something like an Alzheimer's diagnosis, or something that could, in the long run, impair thinking and decision-making ability. And so people come to us all the time with that. And that's a different timeline. Each of those scenarios are a different timeline for how quickly you need to act. But in every scenario, you do need to take action sooner rather than later. Why? Why do you need to take action? The thing I tell individuals is everyone has a plan. When it comes to decision making while you're alive, when it comes to what happens to your assets upon your death, you have an estate plan, whether you think you do or you don't. You have a plan in place for legally who is to make your decisions. You might like that plan, you might not. If you haven't gone through the process of formalizing the plan, then you're not exercising your legal ability to take control of your own plan. But there is a plan for you. There's a plan for what will happen to all of your assets when you die. There's a legal plan in place for how someone goes about making decisions while you're alive. And you either design a plan for yourself, or you live and accept the plan that the government has created for you. And I'm not here to be critical of the government, because a lot of things the government does is great. But I think a lot of us find that the plan the government has created for us is not our first choice. It's not the most efficient, and it's not the most pleasant route for us to go through or to have our family members go through. So, what's the worst that can happen? Why bother planning? The reason we bother with planning is we want to control the process. We want to control our own decision-making process. We want to avoid things like probate court. Probate court comes into play upon someone's death, but it also comes into play upon someone's life. Or during someone's life. If you need someone to make decisions, and someone's not given the authority to a third party to make decisions for them, then probate court is the government's plan for how decisions get made. It's that someone would be legally appointed a guardian for someone else, even as an adult. And that's not always what we want. In fact, that's something we try to avoid at all costs in our law firm. The other reason you want to control the plan is whether it's somebody losing competency or capacity, or whether it's someone who passes away. When when people pass away or when people lose the ability to exercise their own decisions, I find in most family members and clients' homes, it creates a power vacuum. Whether it's mom, dad, husband, sibling, whatever power or authority or influence, I mean that in a positive way, not a negative way, that they've exerted during their life. I know all of my immediate family members have an influence over me. And if they were to lose the ability to communicate or if they were to die, then that influence goes away. So there's always a little bit of a power vacuum. And whenever you have emotions, and obviously these are emotional topics, whenever you have emotions, and even more importantly, when you have money, which comes into play a lot of times, that amplifies emotions. And so you have the combination sometimes in these situations of having a power vacuum, where someone's no longer able to make their own decisions or exert the influence they've exerted in the past. And then you also have money that someone else now has to control, whether it's while they're alive or whether it's upon their death through an estate process. And so that's sometimes a bad combination. And so we want to take steps to exert control over how these decisions are going to be made to better everyone. So looking at decision making. When it comes to decision making, I like to refer to supported decision making. Supported decision making is the process whereby someone else is helping us make decisions. And then sometimes supported decision making becomes substitute decision making. And then sometimes substitute decision making can even become full decision making on behalf of someone else. But I like to say we all start with supported decision making. Supported decision making means while I'm alive, while I'm competent, while I have capacity to sign a legal document, I sign documentation saying that I want this person to help me if ever I need assistance. And I was listening to a public speaker one time who was really good, and he was talking about supported decision making, and he had a big room, and it was after lunch, and you could tell the room was starting to fall asleep, and he said to the room, I hope everyone in here completely agrees that supported decision making is a good thing, and if you don't, I hope you die quickly. And everyone perked up and said, did he really just say, I hope you die quickly? And then it sinks in, because what he's saying, and he's absolutely right, is most of us don't die quickly. We die after an illness, or even when we think of, in my mind, if I think of someone dying quickly, I think of a traumatic medical incident or an accident or something of that nature. But even a traumatic medical incident, like a major stroke or heart attack, there's often still a period where you're hospitalized, you're being worked on in one way or another. And during that period, you're relying on someone else to support or help you making decisions. And so what he meant by that, he's absolutely right. Every single one of us need to be a believer in supported decision making. And we need to have people in place to support us making decisions and then also substituting for us when we can't make decisions. So, specifically, what documents am I referring to? And these are documents that I believe every adult should have. The first is a healthcare power of attorney. I'm a believer that everyone who is an adult, who has the capacity and the requisite, or can satisfy the requisites to sign a healthcare power of attorney should. A healthcare power of attorney, we'll talk about a little more here in just a second. There's also the living will. And oftentimes people think of the living will and the healthcare power of attorney together as advanced directives. And that is what they are. They're both advanced directives. Possibly a HCPOA waiver. A lot of our clients, for one reason or another, we have them sign HCPOA waivers that they can give to family members. We're all familiar with HIPAA being the privacy laws. They govern the protection of our medical information. And sometimes, well, those laws are great, but sometimes they do get in the way of the right people having the right information. And so sometimes HIPAA waivers are important. From a financial side, we need to have a financial power of attorney. Now, it could be a financial power of attorney. You'll hear people call it a durable general power of attorney. There's a number of different names. But ultimately, this is the power of attorney that's saying, hey, this person here, they can manage my financial affairs in whatever way I have laid out in the financial document, the power of attorney instrument. Sometimes there's unique powers of attorney. So you might find, and we'll talk more about financial power of attorneys here in a second, that a third party doesn't accept or recognize your document. You go to your attorney, you spend money, they give you this nice document full of legal jargon, and then you take your financial power of attorney down to the BMV, and they say, you know what, we don't recognize that document. And then you call us attorneys and you say, what in the world's going on? And that's because in Ohio, third parties are not required to accept power of attorneys. And so you got to know who are some of the nuances in this state, or who are some of the entities in this state that have their own forms, and what do we need to do via those entities. And then last but not least, you've got to have a map or a roadmap. In our law firm, we call it a roadmap, and we tell every client you need to have a roadmap in place. And we'll talk more about what that roadmap is. But that roadmap, and I was very glad to see the Central Ohio Area Agency on Aging here has a condensed version that contains some of the stuff we have in our roadmap. It's just a document that sets forth very important information that gives your loved ones a map for how to go forward if something happens to you, whether that's during your life or upon your death. But there's a lot of things that happen in life that don't fit in a will. They don't fit in a power of attorney, but it's information that needs to be passed from you to your loved ones at different times in your life. And you got to have a map that shows them what information they need. So let's look at these documents a little bit more carefully. The first is the healthcare power of attorney. Now, as a preface, in Ohio, it used to be every attorney in the state had their own form or their version of a healthcare power of attorney. And they also had their own version of a living will. Several years ago, this was recognized to be a problem because if I draft this 20-page document full of legal jargon, and as an attorney sometimes I can't get out of my own way, so I make things longer and more complicated than they need to be. And so I draft this long document for you, I have you sign it, now you're in a crisis where someone else needs to make your medical decisions, and you're in the hospital, and your loved ones say to the hospital, here's this 30-page document that our wonderful attorney made, it says who gets to make the decisions. And now you've got social workers or hospital administrators flipping through this document saying, wait a minute, who gets to make the decision, what happens here? And so you still, in Ohio, you have the ability, as an attorney, I have the ability to draft my own healthcare power of attorney. My personal opinion, and this varies from attorney to attorney, is that I would be doing a disservice to my clients if I drafted my own healthcare power of attorney. And that is because several years ago, Ohio put together a panel of doctors and lawyers and a number of other institutions provided input, and they created a standardized advanced directives packet that consists of 3 documents: a healthcare power of attorney, a living will, and then a donor registry enrollment form. In our firm, we have all of our clients sign this as their healthcare power of attorney. We have our clients sign this as the living will. Why? Because I know that if they go into a hospital in Dayton, it doesn't matter that I drafted it here in Columbus, they can hand it to the hospital, and they know. They go to page 3, and right there at the top is the name and phone number of the agent who's making decisions. So, when we talk about a healthcare power of attorney, what we're talking about is a written document that says, if I'm unable to make healthcare decisions, this is who I want making decisions on my behalf. And so it may be a spouse, it may be a child, it may be a parent, it may be a next door neighbor. But you're saying, if I can't make healthcare decisions, this is who I want making them for me. There is truly no risk, in my opinion, to signing a healthcare power of attorney. I cannot think of a downside to signing one. Because as long as I'm competent, as long as competence is the wrong word, as long as I have capacity to make my own healthcare decisions, then the doctors are going to listen to me and only me. So I've signed a healthcare power of attorney, and I've said, if I can't make my healthcare decisions, my wife can make them for me. That doesn't mean that if my wife disagrees with one of my healthcare decisions, that she can step in and say, well, Derek's not thinking right today, he had a headache this morning, so he is going to have that surgery whether he wants to or not. It doesn't work like that. This merely says a doctor has to have my consent to perform treatment for me, and if the doctor doesn't think I have the capacity to give that doctor consent, then I've said who I want that person to be. And so the doctor knows who to turn to for consent for my health care. That is a great thing to have in place, because the alternative, there's alternatives that can take place in an emergency setting, and then there's also alternatives that can take place in a more prolonged setting. But unfortunately, if somebody has a major stroke or somebody has a major life event where they do lack the capacity to give consent for health care and they don't have a health care power of attorney, then someone might have to go to the probate court and establish guardianship of their person, which means the court's appointing someone else to make those health care decisions for you. And that could be traumatic on a number of levels in and of itself. So, who should sign a health care power of attorney? All adults over the age of 18. Now, the statute says, beyond being an adult over the age of 18, the next question becomes, well, what if my loved one has Alzheimer's or has a diagnosis where we're not sure if they can sign it or not? The statute in Ohio says that in order to sign a healthcare power of attorney, you have to have sound mind. I detest that statute because sound mind is not defined anywhere in Ohio law. But the Ohio Revised Code, Chapter 1337, which is the power of attorney statute for Ohio, it says to execute a power of attorney, and this is for both the healthcare and here in a little bit we'll talk about financial. For these power of attorneys, you have to have sound mind to sign these documents. Because that term is not defined anywhere in Ohio law, courts have interpreted it to say you have to have the capacity to sign the documents. And what does it mean to have the capacity to sign a document? You have to understand what you're signing and how it benefits you. Now, my philosophy, and this has always been my personal approach, is that doesn't mean that you've read every single word and you understand every single legal term in the document. I have clients that come in all the time, and I've given them these documents, and I've encouraged them to read it, and I know they haven't read a single word of it, and they come in, and they're glazed over, and they say, Derek, just tell me where to sign. I'm not saying you can just put a document in front of anyone and let them sign. You do, as an attorney, I have to have a conversation with someone, and I have to understand that they know by signing this document, they are appointing a spouse, child, loved one, neighbor to make decisions for them. They have to be able to understand the general gist of the document and the authority they're giving in that document. What does the healthcare power of attorney do? It then gives your loved ones the ability to make decisions for you. Are there limitations? Yes. The healthcare power of attorney does have some specific limitations. By statute, there are certain limitations that an agent in a power of attorney cannot do. A agent through a power of attorney cannot withdraw life-sustaining treatment without also getting physician consent. So that's just kind of a checks and balances. They want to make sure that an agent under a power of attorney has physician consent to withdraw life-sustaining treatment. An agent cannot withdraw an order of comfort care. So comfort care is critical as we age or as we go through the dying process. Comfort care is critical, and an agent through a power of attorney cannot withdraw that. An agent cannot terminate a pregnancy unless the principal, the person who signed the document, unless their life is at risk. And an agent cannot withdraw nutrition and hydration unless there's also a living will and other prerequisites have been met. Lastly, an agent cannot withdraw consent for treatment that the person who signed the power of attorney gave consent for unless there's been a change in circumstances. And so if I have a cancer and I'm going through a certain regimen of treatment for that cancer, and maybe it's very hard on me, and then something happens where I'm not able to make decisions, and so my wife steps in. She cannot say, stop all cancer treatments unless there's been a change in circumstances involving my cancer treatments. Because while I had capacity, I said, I want the cancer treatment. You can also, through the power of attorney, you can, and to the extent you want to, should customize it. The power of attorney has a box on there, and so you can put limitations or instructions in a power of attorney. I've had clients before who had certain religious beliefs. Most recently, I had clients that came through and they were Jehovah's Witnesses. And so they don't believe in blood transfusions. And so it's important to them that none of their agents ever be allowed to consent to a blood transfusion. And so in the standardized form, we wrote in the box that an agent cannot consent to a blood transfusion. So you can always insert limitations like that if it's your desire. We also have a living will. Living will is a document that just says if you're terminally ill or permanently unconscious, and you have the required physician consent, if you do not want them to continue providing life-prolonging treatment or life-sustaining treatment. People, I have clients a lot of times that are sitting at the table and they say, well, is that the pull the plug document? And I say, well, it's the document that says when certain requirements are met, I want them to turn off machines. My personal belief is once I qualify as having a terminal illness or permanently unconscious, as defined in this living will document, I don't want to be kept alive by life-prolonging treatment. That's my personal opinion. And so I've signed a living will because I want my wishes to be known in advance. That's my way of controlling that decision. Not leaving it up to family members, not leaving it up to them going through a guardianship process, not leaving it up to unnecessary and additional consultations with doctors and third parties. I'm saying once I meet those qualifications, it's my desire that the machines be turned off. Financial power of attorney. Everyone needs to have a financial power of attorney. Now, the financial power of attorney just says, first of all, financial power of attorney could say one of two things. It either says, if I'm unable to manage my financial affairs, this is who I want to manage them. Or alternatively, it says, I give this person authority and access to my financial affairs. There's a big difference there. So in a financial power of attorney, it could be immediately effective, where I sign and I say, I want my wife to be able to manage my financial affairs right now. That doesn't mean that she can step in and I've lost the ability to manage my financial affairs. It just means she has the ability to access my financial affairs. Or I can make my power of attorney what's called springing, which means when I lose capacity and when I lose the ability to make my financial decisions, then I give my spouse the ability to manage my financial affairs. Myself, I signed the power of attorney, and I've said, and vice versa, my wife can manage my financial affairs. If I'm off on a continuing education trip in Colorado and I forgot to sign a check, then I like knowing that she can legally pick up the check, sign my name through the power of attorney, and she has immediate ability and authorization to manage financial affairs on my behalf. The financial power of attorney is a critical part of planning as you get older. And so when you get that bad news from the doctor, you've got to make sure you have a financial power of attorney in place. Oftentimes, it's the more neglected of the two primary power of attorneys. The healthcare power of attorney, you've got the hospital that'll give it out, the DMV gives it to you. You can even get it down to the recorder's office. They have nice packets. You see it in a lot of places. The financial power of attorney is more nuanced. And it also needs to be more closely drafted to match what's going on in your life. The financial power of attorney is one of the biggest causes of abuse, because a lot of individuals who are agents under a financial power of attorney take advantage of mom or dad, and it causes a lot of fighting within families. It's also something where a lot of individuals will pull a financial power of attorney off the internet and they sign it, and then maybe whatever's going on in your life involves a stay in a long-term care facility, and then maybe Medicaid comes into the picture or other different government programs. And if you don't have the right precise language in your financial power of attorney, it becomes a big roadblock. And so on multiple occasions, I've had clients who have received that bad diagnosis. They've downloaded power of attorneys, specifically the financial power of attorney, off the internet. They've signed it. Then 3 years later, they are looking at Medicaid eligibility, things of that nature. Then they call an attorney, and then they find out, well, this power of attorney doesn't specifically say that I can create a trust. Or this power of attorney doesn't specifically say that I can move around chunks of assets to, in a very upfront, appropriate way, do Medicaid planning. And it can really come back to bite people sometimes. And so the financial power of attorney needs to take into account what's going on in your life. Obviously, we have general power of attorneys, but as you get older and as you get those specific diagnoses, that's the time where it's worth a phone call or a conversation to say, hey, here's what's going on. Here's what our future may look like now that we know more. What do you think? Do we have the right power of attorneys in place? Now, estate planning. So these power of attorneys are documents that really are governing what happens during your life. So if you have, I said estate planning, but I'm going to back up a second. If you have the financial power of attorney, if you have the healthcare power of attorney, if you have a living will, if you have a HCPOA waiver, these documents working together can help someone assist you during your life. If we've got the right documents in place, and I think I do for most of my clients, if we've got the right documents in place, they should never need a guardian. That's why they shouldn't need a guardian. I can't say never, because sometimes fighting might still lead to a guardianship, but the overwhelming majority of time, you are not going to need a guardian if you've got the right documents in place. These are the documents that allow me or allow my spouse to support my decisions when I'm unable to voice them myself. And so that is supported decision making, having those power of attorneys in place. You've also got to think about, when you get that bad news, it's hard sometimes for people to think about death, but as I said, it's inevitable for all of us, and everyone has an estate plan. Just like during your life, the government's plan for making those decisions is that if you can't, someone has to become guardian. The plan upon your death is that all of your assets are going to flow pursuant to what's called the statute of descent and distribution. And that's a statute that says which of your next of kin inherit your assets if you die without having an estate plan. And for that to be carried out, everything has to go through a probate process. And so it's critical that we have the right estate planning documents in place so that upon your death, we've got a plan that you've customized, that you're comfortable with, that you have control over, that dictates when and how your assets pass. When you think of an estate plan, you've got to think about, one, we like to avoid probate. And so, not that probate's that bad of a place, but we want to avoid it. And for most of our clients, we can, if not always. We want to control the asset distribution. We want privacy. I know for myself, if I were to pass away, I'd want my spouse to inherit everything. We have 3 young kids. I'd want her to inherit everything, and I wouldn't want it all to be public record, and I wouldn't want her bogged down with hearings and probate processes, I would just want her the day after I die to just have it. And it's never ever that easy, but I can make it as easy as possible by doing some planning. We also sometimes want to minimize disputes. Maybe we know our kids don't get along. Maybe we know that our second spouse and our children don't get along. Exercising our decision making by having the right estate plan can help us minimize disputes that could arise after our death. When we think about estate planning, oftentimes we think about a last will and testament. And everyone thinks about having a last will and testament. And that's a critical document. Everyone should have a last will and testament. Just so we understand, though, if you have a last will and testament and you're relying upon your last will and testament to pass assets from you down to your kids, you are guaranteeing that there will be probate. You are guaranteeing that they will have to go to court. What a lot of people don't realize is that a last will and testament, the only place we really use that is in the probate court. Because that says, through the court process, this is who I appoint as my executor, and this is who I want my assets being distributed to. And it's a good thing to have as part of a larger plan, because a lot of us do have assets when we pass away that go through probate. And so it's going to be a lot easier to get those assets through probate if we have that will in place. But we have to understand that that will does not help us in avoiding probate. It doesn't help us in minimizing disputes sometimes. Then people say, okay, well, if it's not a will, how do I plan to get my assets down to the next generation? And so that's where we really come into two options. We always say you can go through a probate avoidance plan where we're going to say, all right, what are your assets and how do we get your assets from you to your children without going through probate? Or we have a trust. And I always say, when you think of a trust, just picture a basket. A trust is nothing more than a 30-page document full of legal jargon. All you're doing is creating a basket. And then either during your life or upon your death, you put all your assets into that basket. The reasons and the necessity for having a trust have gone down in the last 5 or 6 years. And that's for tax reasons. There used to be a lot of attorneys would say everybody needs a trust. And for tax reasons, a lot of people did need to have a trust. I myself believe that a lot of people who have a trust that created it 20 years ago, quite honestly, they don't need it any longer. And a lot of individuals who 20 years ago, if they came to me, well, I would say you absolutely have to have a trust. Today, I tell them you don't. Individuals turn on Susie Orman and some of these talk shows, and they come in and they say everybody needs to have a revocable living trust, and that is not true. You need to have a plan for avoiding probate and a plan for passing assets down to the next generation, and a trust is one of the ways we can accomplish that. The other way we can accomplish that is just having a probate avoidance plan, which just means we sit down together, we go through your assets, and we look at what you own and how we get those assets to the next generation. And this is something that needs to happen. You go through that period where you get the diagnosis and you think, all right, what do I do next? What do I need to do from a legal standpoint? With probate avoidance, some of the things you can do is make sure that for all of your accounts, you have beneficiaries. So your retirement account, you've got to name a beneficiary. Life insurance, you've got to name a beneficiary. Your bank account, your checking, your savings. Probate avoidance is sitting down and talking through, is it the best thing for me to put my daughter as a co-signer on my account? Is it the best thing for me to put my daughter as the payable on death beneficiary of my account? Any of these accounts, any type of financial account that has a beneficiary name, or whether it's you might hear POD, which is payable on death, you might hear TOD, which is transfer on death, or if it has a co-signer on the account, these are all ways that we transfer ownership without going through court. So, for example, a retirement account. If I've got a retirement account with $100,000 on it in it, and it's in my name, because the retirement account can only be in my name, and I never filled out my beneficiary form. When I die, that $100,000 retirement account goes to my estate. And then my estate has to take out all that income from the retirement account, pay the income tax on that, and then distribute it to whoever I named in my will, or alternatively, distribute it to whoever's listed in the statute of descent distribution if I don't have a will. All right, so that's a bad thing, because now we've got a $100,000 asset. Somebody has to pay an attorney to go to court, to go through the probate process, and then they've got to pay a whole bunch of income tax on it. So part of any conversation pertaining to estate plan is going to include a conversation or a discussion about a trust. And I find there's a lot of misunderstandings out there about what is a trust. And so to start with the base question, what is a trust? A trust, I always tell clients, A trust is nothing more than a basket. When you sign a trust agreement, you're signing this document that's pages and pages full of legal jargon. All you're really doing is creating a basket. And then either during your life or upon your death, you're going to make sure all of your assets are passed into that basket. And so you fill up the basket with the things you own. And that's referred to as the funding process. When we talk about a trust, there are countless different types of trusts. We have revocable trusts, we have irrevocable trusts, we have trusts that pertain to avoiding estate taxes, and trusts that pertain to planning for children with developmental disabilities, and countless different types of trusts in between. But the main takeaway for a trust is a trust absolutely can be a vital part of an estate plan for some people. Having said that, a trust isn't as common or as necessary as it used to be due to some of the changes in the law as they pertain to the estate tax. And so the need for a trust on the whole has declined for your average citizen out there, but it's still a critical part of estate planning for some individuals. And if you have a trust, having your assets funded in a trust enables the trustee to manage those assets for your benefit during any period of time where you're incapacitated. And so if you have a large estate and you get that bad diagnosis from a doctor, one thing you should absolutely consider is whether or not it would be better to move your assets into a trust, at which point a trustee, subject to the terms of the trust, can manage those assets for your benefit. And that would help during any period of incapacity, and it also helps upon your death. Because one of the things we can do with a trust that we can't do with a will is exert some control over our assets after our death. So, whereas with a will, once we pass away, the will distributes assets through the probate process to the beneficiaries. With a trust, we can have more controls and parameters on when and how loved ones will inherit or receive distributions. So that if you do have a child or a loved one or a friend that has an issue that makes you think maybe they shouldn't get a lot of money right at once, and you want to stagger it or put some structure to it, you can do that through a trust in ways that you can't necessarily do with a will. You have a child with a disability, and so you want to make sure there's a plan in place that doesn't disqualify that child or loved one from certain government benefits. There's a number of reasons you might need to have a trust, and so you certainly want to consider that as well as an estate planning vehicle. There's additional considerations. There's additional things you have to think about. And these are things that you don't have to get bogged down in the day you receive a bad diagnosis or the day you get bad news, but they're things that in a perfect world we would all think about while we're healthy. And if necessary, then once we get the bad news, we would sit down and think through some other things. And those are, do you want to be an organ donor? Are you already an organ donor? Do you know what you want to have happen to your body? Do you want to be cremated? Do you want to be buried? Do your loved ones know? Because really it doesn't matter if you know if you don't tell someone. Do you have minor children, or do you have children who have a disability so that they need a guardian? If so, then you're kind of on the clock in terms of being able to appoint a successor guardian for them. Do you think you or a loved one are going to need Medicaid? And so Medicaid, we're not going to get into the weeds of Medicaid today, but Medicaid is one of many government programs that assist us that would qualify in certain circumstances. Everything from bringing support into the home to helping pay for long-term care facilities. But there's qualification, there's criteria that you have to meet to be eligible for Medicaid. And so, do we need to think about that? Do you own a business? If you own a business, do you have a plan for that business? One of the hardest things to do as an estate planner is to help small business owners navigate the transition and the succession of their business. I enjoy doing it, but it's like a Rubik's Cube sometimes to figure out how we get the value for that person out of their business. Because a lot of times when an individual with a small business retires, the value of their business goes away. So you have to figure out how to get the value of that and how to do that. Taxes. We've talked very little today about taxes, but nobody wants to pay taxes. In Ohio, we no longer have a state tax or a death tax. We don't have one. And that's part of the reason that so many people that used to need a trust don't need a trust now. At the federal level, we do still have an estate tax. Unless you have more than $11 million, we don't have to worry about the estate tax. So 99.9% of us do not have to worry about the federal estate tax. I always like to joke with my clients that I'm going to find out if you have to worry about the federal estate tax before I tell you what I'm going to charge. But for 99.9% of us, we're never going to have to worry about the federal estate tax. These are all things that come into play, and it all factors into mapping things out. My last point, which is have a roadmap. We call it our roadmap to my firm. Your estate plan, your life plan, your supported decision making, that's all part of a roadmap for what's going to happen in your life. And the roadmap is a document we give clients that starts with a questionnaire, but it also asks for a narrative. And the narrative is non-binding information that we want you to make sure you have available to your loved ones. It can be everything from, do you want to be cremated or buried? We have a questionnaire section on that. But what do you want when you pass away? The majority of the time, our children end up making that decision, or if we're married or a surviving spouse makes that decision. But there's a lot of confusion that comes into play if we haven't had that conversation with our loved ones. It's also, what assets do you own? I was very glad to see this document that the HCPOA is using. 20 years ago, as an estate planning attorney, if somebody died, what to do next was easy. You would tell their loved ones, we'll read their mail. Because if you read their mail for a month, you knew everything about them. You'd get all their account statements, you'd see their retirement account statements, their bank statements, you knew who their homeowner's insurance agent was because you got your monthly bill. You could learn everything about someone from reading their mail. That does not work. In this day and age, as we all become more and more tech savvy, one of the biggest obstacles to people who do what I do is just figuring out what did mom, dad, or even spouse own. It is so common for a surviving spouse to come in, they already have the trauma of having just lost a spouse to illness, and you start talking about assets, and they do not know what they do or don't own. Their husband was the one that did all the finances, or their wife was the one that did all the finances. In a lot of houses, there seems to be a natural division of labor. A lot of houses, maybe the spouse does all the finances, the husband does all the, whatever he does. But there's, a natural division of labor there in a lot of marriages. And so it's not at all uncommon that people don't know. And there's no better tell that proves this to be true than the fact that Ohio's unclaimed funds is going up rapidly. It's growing faster than it ever has because so many accounts aren't being caught or slipping through from one generation to the next. And so it's critical that you have, as part of a roadmap, you've got a plan in place so your kids know, hey, while I'm alive, this is how you're going to help me. I have the documents in place that are going to enable you to help me, and I'm going to make decisions. And then when I can't, you're going to substitute for me and make decisions for me. Then when I die, I've got a plan in place. This is who's going to get my assets, this is how they're going to get them, and this is when they're going to get them. And I've made these decisions. And by making these decisions, you're shrinking that power vacuum we've talked about. Because you're still there in a way that, from the sense of you've laid out a map for how you want this to happen. And then in that roadmap, you've given them everything from what they need to know to fill out your obituary forms, to how you want your remains handled, to what financial institutions they need to contact. And it even has a narrative in there if you want to give your loved one that last lecture, whether it's as a parent or a spouse or whatever loving thing you want to say or however you want to make it. It's all going to be part of that roadmap. And if you have made decisions that you think might ruffle feathers, it's a good time to say, this is why I did what I did, if you choose to. Some people choose not to do that, which is perfectly fine as well. But we're a big believer when it comes to life planning and estate planning, because it's not just estate planning, that you've got to have a map, you've got to have a progression in place so that while I'm alive, I know how decisions are going to be made, and I know we're not going to be going to court. When I die, I know what decisions are going to be made, I know who's going to make them, I know when they're going to make them, and I know we're not going to be going to court. And then all the extra stuff, everything from the, how we take care of the car, to who's taking care of the pets, to how I'm going to be handled, is all laid out in the roadmap. And it takes a lot of the guesswork out of it, and it puts you and your loved ones in a position for success in what's already going to be a very difficult time. I have filled up my time, and I love talking about these topics. And so I'm happy to answer any questions anyone might have.
I have
Oh, me too, but
mine is actually a follow-up. You said there were situations in which a financial power of attorney might not be recognized by institutions. When is that commonly? What institutions does that tend to be?
So certain financial institutions might not recognize the power of attorney. And I find that more with the, because keep in mind, Ohio law says you are not required to accept a power of attorney. And so I can download a power of attorney form off the internet. I can walk into Fifth Third Bank and I've signed it and I've got a notary that signed it. And so I have satisfied the statutory duties for creating a power of attorney. They might look at it and say, this doesn't make sense. This really looks like a poorly done power of attorney. We're not accepting this. They have the authority to do that. The BMV, they have their own BMV power of attorney form. So when it comes to the Bureau of Motor Vehicles here in Ohio, you need to fill out their form. They don't want our form, and they have the right to say that. So in large part, it's financial institutions. There are certain governmental entities that won't accept financial power of attorneys. The IRS is always, they do a good job of scrutinizing financial power of attorneys, and they're very selective sometimes about which ones they will recognize and not recognize. And so it underscores the importance of having the properly written power of attorney. So, and let me address something else that comes up. You sign these documents, and it's not at all unusual for us to have someone sign 2 or 3. And there's no reason that you can't have more than one original out there. But sometimes you get into a situation where a financial institution or a third party may say, we want the original. And again, they have the right to insist upon an original. So then they take your original, and now you're thinking, well, shoot, I don't have an original left if I only had one. You also have the option in Ohio of going to your county of residence, the recorder, and you can record the financial power of attorney. And so what that does is it makes it easier when you give a recorded copy to someone, they will accept it as an original, or a lot of financial institutions will. If I have someone where I'm going to be making all of their financial decisions, then I would strongly consider recording the power of attorney, because now I'm going to have my same document that's going to have the recorder's stamp on it, and that a lot of times will satisfy a lot of financial institutions that do ask for an original. Anytime you're selling real estate, you have to record it. You can't sell real estate on behalf of someone without recording it. Now the trade-off is, once you record it, it's a public record. And so you record it with your county recorder, then anyone else, your neighbor or your nosy friend next door, they could get online and they could read the power of attorney. And so keep in mind, a power of attorney, it only gives your agent the authority that's specifically stated in the written instrument. So they got to be broad. And that's why I always get alarmed when I hear about, one-page power of attorney, because you want to be specific and include specifics about what authority the agent has. But good question. Yes?
Mine was about the do not resuscitate order. My mother's 84. She has one signed, but I think it was 10 or 15 years ago. Does that last forever? Or she does have Alzheimer's now. I don't think she would be considered competent to sign anything again. But she does have one signed, but it's been several years.
Okay, so DNRs, and a lot of times there's confusion surrounding DNRs and living wills and things of that nature. So DNR standing for do not resuscitate order. Clients come in all the time and ask us attorneys, well, should I have a DNR? And we tell them, we can't prepare a DNR for you. It's got to be signed by a physician, not something we prepare. To my knowledge, though, there is no expiration date on a DNR. It can be revoked orally or in writing at any time. All I have to do is say, I revoke my DNR, and that revokes it. But there's no natural law that says
so whatever she signed 10 years ago is going to still be in effect.
Unless revoked, yes.
Yes. Okay.
Good question. Yes?
Are these forms recognized in other states?
Are these forms recognized in other states? That's a very good question. Generally speaking, yes. And so when I say generally speaking, the United States has what's called the full faith and credit clause of the Constitution, which says states have to recognize contracts properly drafted and executed in other states. Estate planning documents are nothing more than, at their core, they're a type of a contract that says this is how my assets are going to flow. I should say kind of a quasi-contract. States will recognize estate planning documents properly drafted in other states, with the big caveat that most states, like Ohio, make accepting power of attorneys permissive, not mandatory. So while I say, are they effective in other states? Yes, but that doesn't mean I could draft a power of attorney that every single person in Ohio would accept, and you could walk into a bank in North Carolina and they could say, no, that doesn't look like a North Carolina form we're used to. We're not taking that. So you always run that risk. You run that risk in Ohio as well, which is why you want to make it a good document. But So I can't guarantee that a power of attorney is going to be recognized by every institution out there in every state. Because just like Ohio, most states are permissive, not mandatory when it comes to accepting a power of attorney. As to a last will and testament, yes, that would be accepted in other states if properly executed and drafted in Ohio.
What about medical power of attorney and going to another state?
So medical power of attorney, same thing as the financial power of attorney. Generally speaking, I find that medical institutions they exercise a lot less scrutiny over healthcare power of attorney than financial institutions do over a financial power of attorney. And so I'm not aware myself, I can't say that I've ever heard of a hospital out of state rejecting Ohio's healthcare power of attorney. That's the one I use for all of my clients. I've had clients, I even had one who was in a car accident in Jamaica, and it worked just fine. I mean, the spouse called me, and I emailed it to her. And now, once you leave the country, all bets are off. I have no idea what's going to happen in other countries. But in this case, they were in Jamaica in a bad car accident. I emailed a copy of the power of attorney to the spouse, and it worked. She was able to make all his health care decisions.
How do you know, because you keep referring to properly forms that are proper, blah, blah, blah. How do you know if you went to an attorney and if this is proper or not?
If you went to an attorney, I mean, I'd like to think that the vast majority of us know what we're doing. And that if you went to an attorney, then I'd like to be optimistic and say that I'm sure you have a well-drafted document. One of the things you want to remember, though, is were the circumstances the same when you went to that attorney as what they are now? If you've had a change in circumstances since you met with that attorney that might not have been discussed with that attorney, then you might want to have them checked. One thing that has come up, especially in the context of Medicaid planning, in a lot of power of attorneys for years, attorneys were of the opinion pretty much across the board that in a financial power of attorney, why would you give an agent the ability to make a trust on your behalf? Why would you give them the ability to do estate planning on your behalf? Well, then we had a change in laws as it pertains to Medicaid eligibility a few years ago, and one of the key pieces of getting Medicaid eligibility now is creating a certain type of trust called a qualified income trust. And so what happens, we find a lot of clients that need to do Medicaid planning have a power of attorney that's outdated, and it doesn't specifically say if the agent can create a trust. And so we have a lot of trouble getting eligible, or we have a lot of trouble sometimes creating a qualified income trust if the power of attorney doesn't give them that authority. And so, circling back to your question, if the attorney, I would like to think the attorney did a good job, but if there's been a change in circumstances, or if a lot of time has passed, laws do change. And so it may be worth sitting down with someone and just having a review or a checkup to say, hey, is this something I need to expand? And that also goes back into our timeliness. Now, you've got to understand your timeline. If your timeline is, we're having a major surgery on Monday, you got to act quickly. But what happens for a lot of individuals is it is a diagnosis of some type of Alzheimer's or something of that nature that causes dementia. And then we have a progression, and it's not overnight. And for signing those documents, I don't like to think of it this way, but it's true. You're kind of on the clock. I mean, you can sign those documents. A diagnosis doesn't prevent you from being able to sign these documents, as long as you understand the documents. And it may be that you understand them at 11 a.m. and you don't understand them at 5 p.m. And that's fine. Just make sure you sign them at 11 a.m. Because if you understand them when you sign them, that's valid and that's enforceable. And so as that changes and as those opportunities for signing the documents get smaller, make sure you do this now and you check on the documents now. Don't wait until the individual is to the point where they may not have capacity to sign documents, because then you might have regret that we didn't do something sooner.
Got another question. On a lot of bank accounts, should you put Janine and Ronnie Lovejoy or even on titles? It drives me crazy because you never know for sure what you should be putting on there.
So again, how do we title bank accounts is a very critical part of our conversation when we're doing estate planning. And the answer is very case specific. For right now, for my wife and I, all of our accounts are joint. I mean, we have 3 kids in elementary school, and because we have kids, that means we don't have money, as most of you know. So all of our accounts that we have are in joint accounts, and it works just fine, and that's what's best for us. As we get older, there are certain reasons that it might not be best for us to have joint accounts. Whether or not you see a lot of people that come in and say, well, I put my daughter on my account, or I put my oldest daughter on my account. And then you get into all kinds of issues. Well, does your oldest daughter get along with your other 3 daughters? You got to understand what happens to that account upon death. And so this is how it should be done. It's all going to be more fact-driven for what's going on in your life. If we're doing Medicaid planning, that may impact how we title accounts. If we're doing planning for taxes, that would certainly impact how we're titling accounts. If we're planning, if somebody's in a process where they aren't making good decisions and they recognize that, then we may talk about how to title accounts. But it is confusing.
What about car titles?
So I like to call cars my 3-hour headache.
Yeah.
Cars are a 3-hour headache, and I say that when I meet with people who are estate planning. You can make a car transfer on death, and the BMV has a specific form you have to use to make the car transfer on death. You can do that and should. If you have a car, especially a classic car, any kind of vintage car, if you have a boat, anything like that, absolutely go to the BMV, get their transfer on death form, and on your death then, all we have to do is present a certified death certificate and we can change ownership of that car. Easy. The problem is, every time you go to the BMV, I call it a 3-hour headache. I mean, that's what it is. You go there, you take your number, you wait in line, it's a pain. I can't wait until we get more of it online. Depending on what's going on, sometimes I say, if you're younger and you know you're going to go through 3, 4, 5, 10, 20 cars between now and the time you die, that's one of the few areas where I like to joke sometimes, and maybe you just want to stick it to the kids and let them deal with that headache when you die, depending on the circumstances. So, because it's hard, at my age, I'll be honest with you, I'm not willing, because my wife and I, we normally buy used cars, I'm not willing to go to the BMV every time I buy a car and do the TOD form. It's more of a headache than I'm willing to do. Now, if I were diagnosed with terminal cancer and I knew I was going to pass away and I knew the car's in my name, I'm absolutely going to go to the BMV and do the TOD form. And so it's a function of convenience and balancing convenience with risk and everything else that's going on in your life. Yes.
Could you speak to the wisdom of having more than one person listed as your durable power of attorney? It gives you the option of that, like first, second, and third.
Absolutely. All of these documents should have a primary agent, a backup agent, a successor agent. You can even have co-agents, whether it's healthcare decisions or financial decisions. Sometimes parents come in and they say, we want all 3 of our children to make decisions together. And so we'll put on the healthcare form, see Exhibit A, and on Exhibit A, we'll spell out all 3 of their names, and we'll say whether we want them to have to all sign off or how they make decisions. And that is enforceable in Ohio. There's a lot of merit. It doesn't do me any good to have a power of attorney that just names my spouse as my agent, because if she dies before me, and maybe I have Alzheimer's and she's in a car accident, now I'm in big trouble. And now someone has to become my guardian to continue making decisions for me. And so it's a great point that was made. It's critical that in these documents we name backups. And it is hard because some people come in and say, you know what, there's just no one I trust. And that does happen. But it's critical that we dig deep and we try to find someone that can assist us as we age. We're all going to need that assistance on some level at some time. In the statutory form, there's still a few things I like to change about that form, especially if you're doing Medicaid planning. There are a few things you need to change about that form, but you can download that. Yes, Paul.
So, talk about whether you should put things in a safe deposit box or not.
My personal opinion is that safety deposit boxes are going the way of the dinosaur. And I do not believe it is worthwhile to put assets or materials in a safety deposit box. I strongly recommend against putting estate planning or power of attorney documents in a safety deposit box. Recent changes in the law have made it slightly easier to access safety deposit boxes, but it is still a process you have to go through in order to get access to a safety deposit box. I myself, our estate planning documents are in a little fireproof safe in my wife and I's basement. And I recognize that a burglar could easily carry that out. They're going to be incredibly disappointed when they get it open, and all they see are my papers and a few pictures. But that's it. And it's my personal preference though is I'm not a big fan of safety deposit boxes because it's not as easy as you would like it to be to get access to it. If you are going to have a safety deposit box, make sure you have talked to your bank about who you want to have access to that safety deposit box on your death. The big mistake you can make is to not talk to your bank in advance and fill out, and every bank has slightly different forms, but you can fill out forms at your bank as to who you want to have access to your box upon your death and who you want the owners of your box to be. Make sure you fill those forms out. Yes?
Should you give an executor of your will a copy of the will now, or do you just wait till they find it, or where to get it from?
So the answer is absolutely not just wait until they find it.
Okay.
That's going to be part of your roadmap, and that is a personal decision for everyone to make. I have some clients that want to give copies of all their estate planning documents to everyone, and that's fine. I have other clients who don't want anyone in their family to know what their estate plan is, and that's fine. And I understand both sides of that coin. What's critical is that the right people know where the documents are and have access to them when they need them, which in some ways ties back to the safety deposit box. People have to know where they are and they have to have access to them. That's what's critical. Whether you give them a copy of it now or not depends on you. A lot of families see that as a way to ward off future fights by sitting down with the kids and saying, look, here's our estate plan, here's how this is going to work. I have many clients say that's something they've talked about after Thanksgiving dinner. They've all just sat down and said, this is how it works. It's important that they know where it is and that they have access to it when they need it. If you're in a car accident, someone needs to know this is where the documents are and this is how I get to them. Good questions.
Questions?
Well, yeah, go ahead.
Oh, and calls for talking to someone like.
Well, it doesn't have to be me. There are lots of attorneys out there that do estate planning. And so here's the general advice I'll give. When you're engaging someone about estate planning, talk to them about how frequently they do this. Ask them, how often do you do estate planning? Ask them questions. When's the last time you did estate planning? How often do you do probate? How often do your clients have to go to probate? Just ask general questions. And then in terms of costs, make sure you understand the costs. As part of your initial meeting, and most often there shouldn't be a charge for the initial meeting. Generally speaking, most attorneys don't charge anything for that initial meeting. Some do. But when you go to that initial meeting, make sure you have a clear understanding. Attorneys should always have a written fee agreement with their client. There should be no surprises at the end. You should know before you've ever written a check, this is who I'm engaging, this is how they're billing me. Some attorneys do flat fees. Some attorneys bill hourly. For the first part of my career when I did estate planning, I billed hourly. I've now switched to flat fees. And I like the flat fee a lot better because the clients never worry about calling me. If you have a question about how to change a bank account or something of that nature, you're going to pick up the phone and you're much more likely to call me. And we're much more likely to have a complete representation as opposed to you only calling me every now and then because you're worried that it's going to increase the cost of the claim, increase the cost of the service. And so whether it's a flat fee or an hourly fee, just make sure you have a written fee agreement with the attorney and that you understand going in, what is it going to cost and what am I paying for? The value and the cost of an estate plan, I've done estate plans that cost $500 and I've done estate plans that cost $5,000. I mean, it is all a function of the scope of work. What are your assets and what do we need to do? And are we doing a trust plan? Are we just doing wills and probate avoidance? And there's different levels of complexity to go with each. You're welcome. Yes?
I have a lawyer who has advised me to do certain things, and I don't think I have complete coverage. Should I go back to that lawyer? Should I get another lawyer?
So that's entirely up to you. You always have the choice of going to the attorney of your choosing. It's your absolute right to determine which lawyer you want representing you. And I would encourage you to start with the attorney you originally worked with and just ask him if you have what you need to have. And if you do, great. Maybe it's just a situation where you don't understand that you already do have something. And if you're not,
That's very likely.
if you're not comfortable after talking to them, then I wouldn't hesitate to get a new attorney.